whereby the spouses were married in terms of customary law.
Yeah.
There were no problems. Okay. Then issues came when they wanted to divorce. Right? Then as they divorced, the papers showed that these people actually went and entered into a civil marriage.
Yeah.
And then before they concluded that civil marriage, they signed an antenuptial contract. Remember, they were married in terms of customary law.
Yeah.
They switched into civil law, and they entered into an ANC. Right? They purportedly relied on Section 10 of Recognition of Customary Marriages Act. Section 10 of the RCMA, I'm going to abbreviate it to RCMA, says that if you are married in customary law and you have a customary marriage, you may switch to a civil marriage. Right? And when you switch, you may then decide whether you sign or you decide whether that marriage which you switch into is in community property or outside of community property.
Yeah.
Relying upon those provisions, these people then signed an ANC, antenuptial contract, into the civil marriage.
Yeah.
All right? Then no problem. They lived. Then divorce came. When they had to divorce, the other party said, no, man, the ANC which we signed for the civil marriage is invalid. Reason being, there was an existing customary marriage.
Yeah.
Okay? Then the other party then said, no, Section 10, subsection 2 allows us to switch from customary to civil, and it also allows us to sign an ANC. And then the other party said, no, if it does allow you, then it is unconstitutional. Then what the High Court did and said, hey, this is a complex matter. Let's pack the divorce, and then let's look into Section 10, subsection 2.
Yeah.
Okay? Then the High Court then ruled that no. Section 10, subsection 2 of RCMA is unconstitutional to the extent that it allows those that are married in customary law to transition into civil law and sign an ANC.
Yeah.
Then it declared that provision to be unconstitutional. What happens in South Africa is that when a High Court declares law to be unconstitutional, that order must be confirmed by the Crucial Court. So it was not an appeal or anything. It was confirmation proceedings before the Crucial Court. So the Crucial Court had to grapple with Section 10, subsection 2 as to whether the declaration of constitutional invalidity is competent.
Yeah.
The Crucial Court disagreed and said the High Court misinterpreted Section 10, subsection 2. It does not actually empower or entitles or allow those that are married in terms of customary law to switch into civil law and even have the opportunity to do an ANC.
Yeah.
So they remain bound by the status of community of property from the customary law. So you can switch, is fine, but you remain bound by the status. Whenever you sign an ANC in the process, that ANC is invalid. Yeah. Because the legal process is post-nuptial contract. I think you also asked what is the difference between the two.
Yes.
An ANC, and not the political party.
Not the political party, yes. We're speaking about an anti-nuptial contract for those that are confused.
Absolutely. The ANC must be entered before the marriage is concluded. And there is this burning legal question as to, can you enter into an ANC after or before lobola? That question has not been resolved. Others say lobola establishes a marriage.
Yes.
I don't think so.
Yeah.
But I'm not going to debate that. But let us then just advise people to say, enter into an ANC before lobola, just to avoid problems. Because the court can say, no, it was invalid. You sign an ANC before you concluded the marriage.
Yeah.
Then you have it notarized by a notary public. It's a specialist attorney that notarizes it and then register it with the deeds public.
Yeah.
Okay? Then you get married outside of community of property. But if you're married in community of property, somehow you want to switch to out of community of property.
Yeah.
You can no longer do it out of your own volition. As parties, you can't just sign an agreement and say, well, we are switching. What you must do, you must conclude a post-nuptial contract.
Yeah.
A post-nuptial contract is done through judicial oversight. By judicial oversight, I mean one must bring a substantive application in terms of Section 21 of the Matrimonial Property Act. Then the court is going to consider the interest of all the parties, their status. Because you as a gentleman, you might want to bring that application because you want to deprive your spouse the assets. A court will never grant a post-nuptial contract if it's going to be prejudicial to either of the parties.
Yeah.
So it must be that we are matured about it, we have no problem with it, we just want to switch. The court will allow you. But if somehow the order stands to benefit either of the parties, then you're not going to succeed with a post-nuptial contract.
Yeah.
So the parties, or the matter that we are talking about, they ought to have pursued post-nuptial contract instead of antenuptial contract. But I do not blame them. I also do not blame my colleagues who advise them. Because when you interpret Section 10, subsection 2 of Recognition of Customary Act, it gives you that idea that it does allow.
Yeah.
So if I was interpreting that section, I might have given them the same advice. Right? It is just that the court said no, that advice which was given and the procedure which they followed is incorrect. But what is fun and interesting is that there are 3 justices there by the Collegial Court who actually agreed with the other spouse to say it does allow.
Yeah.
So what the Collegial Court does is Collegial Court works with majority rules. 9 justices or 9 judges sat and decided that matter. 3 of them said yes, it does allow. 6 said no, it doesn't allow. So because the 6 is the majority, then their ruling becomes the order.
Yeah.
That is the one that binds me and you now. So that is then the position we are now. I kind of agree with the minority judgment because when I read Section 10, subsection 2 this morning, I kind of interpreted it in a manner that it allows the parties to switch from customary to civil,
Yes.
and it does allow them to switch from in community to out of community. But because the Collegial Court has pronounced that no, such an interpretation in the court words is untenable,
Yeah.
we are bound by that interpretation.